This is a murder case. The suspects are alleged to have committed murder of the deceased. And as I've clearly stated, the first respondent is the estranged wife, who were last seen by the deceased, with the deceased, in his house at Mangu. She had reported a case of a missing person, and upon discovery of his body, the case was booked at Mwangi Police Station by OB number 2/12/10/2022. The deceased also had a motor vehicle, KBY 849Y, make Toyota Hilux, the Vigo double cabin, black in color, which was recovered from the first respondent. Preliminary investigation conducted by the police shows that the suspects in court are linked to the murder. And Your Honor, there is a worker by the name, there's a missing person by the name John. He's only known by one name, John. He was living at the deceased house in Mangu, who is missing to date. And the presumption are that if the deceased was eliminated, he must have been eliminated too. So going by the nature of this case, it is complex. The 24 hours granted by the law is not sufficient. The matter was, they were arrested on Friday, and a lot need to be done in order for evidence to be gathered, so that the person who is culpable is arraigned before this court to take plea.
Your Honor, merely provides the period for which an accused person ought to be brought to court. Because, Your Honor, every matter brought before a court, Your Honor, perhaps you could let the client sit as we urge. Yes. Thank you. Thank you so much, Your Honor. Thank you, Your Honor. You have before you, Your Honor, two persons who are brought before the court without any charge whatsoever. There is no charge. And they have been in police custody for the last several days, since the 14th. And what the prosecution is asking you to do is to extend time for them to be held further. Does not have any jurisdiction or authority to extend time. It is simply not provided for anywhere in the law. And a court, Your Honor, cannot be asked to do what the law does not allow it. And if, Your Honor, there was a provision permitting the court to extend time, I'm sure the prosecution would have adduced it. So again, Your Honor, this is an application without merit. Generally, the defense is not objecting to the police doing their investigations. That is their constitutional duty, and nobody can curtail their right to do that. But that duty, Your Honor, must be done within certain parameters. And it is those parameters that they do not want to adhere to. And they want you to assist them so that they can breach the law. Because, Your Honor, we will give them, or we will regularize that kind of intention. And I urge Your Honor to refuse to do that. I don't know where they got that, Your Honor, but it's a matter that will be conversing at some later date. But that is not a matter that is considered. You are also told, Your Honor, at paragraph 6, that a vehicle had been recovered. Your Honor, just to keep the record straight, our client drove that vehicle to a police station. She has been very, very cooperative, and this is a matter the prosecution doesn't seem to want to bring before Your Honor. If our client subject themselves to DNA, they can do their DNA if that is the part of their investigations. They want to subject the clients to medical examination. The High Court, Your Honor, has ruled on this. Medical examination in this kind of a trial is not mandatory. But remembering, Your Honor, that we don't have any trial, all these matters, Your Honor, are neither here nor there. My main contention, Your Honor, is that the matter of extension of time has been removed from your hands, luckily, by the High Court. And these are matters that the prosecution is well aware of. Release the persons brought under a miscellaneous application so that they can be presented at such a time as they are now ready. The general rule that has emerged through all these authorities, Your Honor, is the fact that it is not proper for the police to arrest first and then commence investigations. That, Your Honor, is a deprivation of the right to liberty.
Right, and espoused in Article 28 of the Constitution, Your Honor. Your Honor, your hands are tied to the extent of Article 40.
Because such sections have not been used to be relied on in founding this application. What has been used is Article 49, 1, F, and G. So the sections that are now seek to be introduced are foreign to the application. So prosecutor cannot now come and amend in piecemeal.
And we have come within the law within 24 hours to seek for time to curtail. It is not permanent, it is temporary. We are seeking 14 days. We are not going to stay with the suspects forever. So this is reasonable within the law. That you allow the orders sought by the state and have the suspect detained for 14 days. As I stated earlier, this is not an ordinary murder. It is complex. One person is missing, and the life of an individual is key. Life cannot be taken away without knowing the cause why somebody is missing. And I would like to tie that. The first respondent reported a missing person, and that missing person was found murdered. And that is why the court should take this seriously. I humbly submit.
To deem that this application is brought under Section 36 of the Criminal Procedure Code. It is said to be a complex matter, and investigators need more time. Just to put the pedestal herein, and to balance the interests of the parties, it will be of less prejudice if the period that is requested, I can see that it is the 14 days, but the court will allow the period to be for 7 days. Yeah? So the application dated 17th October 2022 is allowed for a period of 7 days. Then we shall mention it on 24th of October 2022 for further orders. Yeah?
Yaka.